14th, and is that the new format?
No,
No.
the week after will be new format.
So we will roll into a new format the week after that, whatever that date is.
June 26th is next week.
Well, then why does it say here next is 6/14? Is there a meeting on 6/14 or not?
Yes,
It is.
which is next.
But it's next week. You said there was.
Oh, I see. No meeting Thursday of this week or Tuesday of next week. Is that what this means?
After that.
Thank you, Georgia. Okay. No meeting this Thursday or next Tuesday. There is a meeting on June 14th, and then the following week we will roll into a new format, which is a longer meeting. How many hours?
4 hours from 1 to 5. And the detailed agenda will be available on Tuesday prior, so the 19th of that week.
And the point of this new format is it will be a much more work-driven and staff-driven agenda where we are sort of moving out of educational mode and into getting our work done. And so it's a structure that will allow for regular reporting on work in progress. Any other announcements before we get rolling? Okay. We have approval of minutes for May 29th. That's the only one.
Move to approve the minutes of Tuesday, May 29th, 2012.
Second. Any questions or changes? All those in favor say aye.
Aye.
And Con won't be with us today, obviously. Not obviously. And we are going to, we have just one agenda item other than little nits and mice of new business, and that is we're going to hear from Georgia and Mike today regarding H559, which is now, I take it, Act 171.
Yes.
And what it means for the Green Mountain Care Board.
So I'll start. The board had asked for an update on what had happened in the major health legislation, this legislative session, so Mike and I worked together to come up with this. Basically, we're just going to get behind this of it. There's a bunch of little pieces that we're not really going to talk about in depth, including some blueprint modifications, sports injuries, some shifting responsibilities around within the administration. I'm doing everything that's not related to the board's work, and Mike's doing everything that's related to the board's work.
And Al's doing the sports injuries.
Yes, and Al's doing the color commentary.
I'm the result of sports injuries.
It's all making sense.
So we categorize these into 5 major areas, basically insurance compliance and exchange-related things, immediate insurance market reforms, things related to transition around global commitment and other waivers that the state has, malpractice reform, and then the largest category for us, which is related to our own work. In terms of the exchange and insurance compliance, the Act 171 has required that all employers with 50 or fewer employees participate in the health benefit exchange in 2014, and then it goes to 100 or fewer in 2016, which is one of the choices that states had under the ACA. It also adds in the ability for bronze plans to be sold, which is a change from last year, and dental plan, and provides some accommodations around dental plans in relation to how they're structured with qualified health plans. It also merges the individual to small group market and says that there's no small group individual market outside of the exchange available to Vermonters. It provides some parameters and requirements around both navigators and brokers. And then says that we have to approve a full range of cost-sharing structures in the exchange and allow insurers to offer wellness rewards and discounts, which is built off of existing regulatory structure that's currently in FINRA. And then it just has some timing and reporting requirements around the exchange for the administration. The immediate insurance market adjustments, and immediate because they start right away, not necessarily are occurring right away. The first is specialty tier drug coverage. There was some concern that there were annual limits being imposed on individuals because of certain high-end drugs. So this says that health plans cannot impose annual limits, and then limits the exposure for consumers for high deductible plans. So it's definitely a consumer savings piece. It outlaws discretionary clauses, and discretionary clauses are provisions that were in insurance contracts that basically said all this other stuff we put in this contract is meaningless because we can interpret the contract as we see versus how you might see it, subscriber. So those are outlawed effective July 1st, and that's in health, life, and accident, I think, coverage. I may be wrong about that. There's also two provisions that I thought were very important to the board based on our discussions we've had. One is there's a limitation on the number of prior authorization forms that are allowed. So one form for procedures and tests, and then the language says as many as needed for prescription drugs. And the process is that the Department of Financial Regulation has to work with carriers to develop these forms over time, and they would be effective March 2014. So the figure that's about the amount of time it would take to develop them and then get them rolled out. Regarding mental health parity,
Where you go on, and the as many as needed is determined
by this group,
DFR.
by DFR with providers and carriers. There's also some work on the federal level around streamlining prior authorization forms. So the bill allows for, the law allows for coordination of that. So if something really magical and streamlined comes out from the federal level, the state can adopt that if they choose. Regarding mental health parity, it creates a mental health care ombudsman, so similar to our healthcare ombudsman that's assisting us, creates one specially focused on mental health care.
Located where?
Within the designated agencies. But I think physically the person is actually someone who's working at legal aid. I think is the person who's selected, but it's through the designated agencies.
Will their role be similar to our current healthcare ombudsman?
I think their role is, their responsibilities are pretty broad in the moment. They're actually discussed more in the mental health legislation that passed related to the state hospital. And there's some question about funding for them, so I think it's actually a role that's in development right now.
And it's, the Department of Mental Health is directed to establish the ombudsman, so that may be where it resides in some way.
And then Department of Financial Regulation has to study and then implement how to distinguish between primary care and specialty care so that there can be true mental health parity. We've heard from folks who testified to us that it's hard that they're being charged with specialty co-pays for things that they consider to be primary care. So this requires FinReg to look at that, determine what's currently happening, and work with stakeholders to make a decision as to what's primary and what's specialty for co-payment parity. For malpractice reform, there were 3 pieces that came out of the malpractice reform component this year. One is a requirement around a certificate of merit, so that that you have to go have a certificate of merit before you can proceed with a court case. And then secondly, it allows for pre-suit mediation, which in some jurisdictions has been shown that that's helpful in avoiding litigation. And then the administration is required to do a medical malpractice reform discussing results and how these two things affected malpractice insurance and providers.
Now, this certificate of merit, in which the claimant must have an expert opinion about the validity of the claim before it's filed, right? And the question is, who determines the certification or the qualifications of the expert? Because that somehow, that comes around an advisory panel and rules of evidence. And I didn't understand that.
So I'm certainly not the expert on malpractice reform. So I can take your question back to the folks who know more about this, because I don't know exactly how they're going to implement this this piece, so I can get back to you on that.
And then there's a disclosure and apology section too.
Yeah.
That was part of the reform. This, you know, as a physician, these questions come to me almost on a daily basis about what you're doing. So I want to make clear to my colleagues about the most controversial issue is who determines the expertise of the certifier.
I've just taken a quick look
Yeah.
at that section. And I think what that section is contemplating is that a court would make a determination that the provider would qualify under Rule of Evidence 702, which is the general, qualification
Right.
for
Okay.
for an expert, qualified to testify about that patient's condition, et cetera. That appears to be the construct of the statute.
So you file a complaint with the certificate of merit, and the court decides whether the certificate of merit has merit, essentially?
Yeah, looking at the language here, that appears to be.
I didn't think you could file the claim until you had an expert certify the merit of the claim. And the expert,
It says to file a certificate of merit along with the complaint.
Right.
right. But unless you have that certificate, you don't file.
That's correct.
Yeah, okay. That's the,
But then the court decides whether the certificate that goes along with your complaint is a valid one.
Right.
So you could submit a certificate of merit from Anya saying that this case has merit, and the court would say, well, so what? We don't care what
And in practice, what would most likely happen is the defendant would look at that certificate, and that would become another potential grounds to dismiss the case, as a threshold matter.
and this won't go away. Medical malpractice reform will not go away. This is just one small step forward.
The next large section of things, global commitment and Medicaid transition, this relates to some challenges that the legislature and the administration had, where we were waiting for some guidance, the state's waiting for guidance from the federal government, or decisions had to be made when the legislature is not in session. So this is to authorize administration to apply for certain waivers and to work with the federal government on things related to health reform implementation in Vermont, but also is coupled with significant legislative oversight. So there's monthly reporting and calls, there's a very extensive structure for the Healthcare Oversight Committee that's in here so that the administration can be in communication with certain key legislators or legislators on the committees of jurisdiction around these really big moving pieces. And then there's a lot of intent language and requirements that say an administration, when we come back in session next year, you report back to us and you tell us what happened and what new information you got from the feds. So this is a lot of work that kind of abuts the board's work, but really is being handled by the administration. As I said, this back January 15th, all of this reporting information is due formally to the committees of jurisdiction. Now I'm going to turn it over to Mike for our
Spanish lesson.
for your Spanish lesson. They were really boring slides, so I was trying to do everything I could to make them a little bit interesting.
I'll kick things off by asking the board members a little quiz. What is George's favorite section of H5?
How you can't answer.
Enforcement?
Kind of.
Not merging.
Position transfers.
Excellent guess.
Consumer protection.
That's what I was going to say, consumer.
Another good guess. It's actually section 25, health insurance rate review, expanding our time frame from 10 business days to 30 days.
We should have known that.
We should have
I think
known
she
that.
likes the position transfers too, though.
I do like that one too.
Yeah.
It's hard to rank them.
And bill backs.
Bill back.
So let's start with billbacks because that's in the, I'm just going to sort of move through the section by section and hit each section that addresses the, things that the board does and will be doing. Section 5 addresses a few sort of general points under the heading of the board's authority. Empowers the chair to apply for grant funding, just kind of puts that there explicitly in statute. Creates a billback provision related to hospital budgets and data allowing the board to bill back for certain expenses in those realms. One of my favorite sections empowers the board, explicitly in statute to issue subpoenas, examine witnesses, administer oaths, and require the production
Cool
of.
stuff
That's right, that's right.
that you've always wanted to do since you were a little boy.
Yes, I'm drunk with power.
Marriages?
Not
What
yet.
about divorces?
So helpful elements there to sort of round out the board's authority.
And on the bill back, if I remember, we have to provide a report to the legislature annually on how we,
Just one report, not annually.
oh, okay. So next year, we have to
Next
provide a
year.
report saying how the bill back, what it pays for, and how it gets allocated.
Exactly, along with any recommendations for changing the mechanism that's currently in statute.
Sections 6 through 11 deal with the unified healthcare budget. That has existed in statute for some time under the department's heading, and these sections move it over to the board and move the definitional sections over and assign that function to the board. There's a number of sections there simply because there were a number of different places where it appeared, and each section sort of corresponds to a different place. Just making that transition clear. Sections 12 through 22, you can sort of think
Michael,
of. Yes.
just on that, either in the original bill or in language here, does it specify anything about what exactly is to be included in the unified health budget, or how to define health or anything else?
No.
The language is in the preparatory materials for tomorrow's advisory committee meeting in the background memo. You'll see the actual statutory language.
Yeah, it's a pretty open field. Like I said, sections 12 through 22 relate to certificate of need process. Again, a lot of sections there just because there's bits and pieces of that in various parts of Vermont statute. But to kind of summarize the key points, it's entitled certificate of need. It's section 12 deals with 18 VSA 9375, which is the section that it gives you your various powers and duties. So that is one of the places where you find the time change in the rate review. That's your other favorite section. Section 12 also makes clear that the board now has authority over hospital budget review and over certificate of need review as of January 1, 2013. Hospital budget review, that's yours now, essentially. The unified healthcare budget appears in there as well because that's also in section 9375. The department's statutes, I forget which chapter that is in Title 18, but it's the 9400 series. These sections amend those statutes to make clear that it's now the board performing those functions and not the commissioner. So they kind of go through the certificate of need stuff, the hospital budget stuff, and make clear that it's essentially changing commissioner to board wherever you find it. Within those statutes, there are sections, subsections dealing with specific enforcement powers that are now, that authority now belongs to the board. So that's all part of that package there. Section.
There's one little provision in there that
thanks.
requires the board to review mental health and substance abuse treatment data and discuss it with our mental health technical advisory group. And that was a piece that used to reside in the Department of Financial Regulation as part of the task force that was eliminated in this bill. So that the board took over that portion of the responsibility.
Thank you. Moving along, section 23 makes sort of the analogous changes to the hospital budget statutes that used to belong to the department, replacing commissioner with board and making clear that those duties and powers are now reside with the board. Section 24 addresses provider bargaining groups, and it just makes explicit in statute that the board is one of the state agencies with which provider bargaining groups can talk and not run afoul of antitrust law and things like that. It also expands the range of topics that can enter those discussions.
These expands the topics, but this is not all inclusive topics, right? It just a bargaining group can only come before us to negotiate these topics.
No, these are added.
These are added to the list.
Correct. Correct. Then we get to George's favorite section, 25, health insurance rate review. So this section amends the statutes in Title VIII as we all know, the department retains a role in health insurance rate review, so it's not a complete replacement like hospital budgets or CON. But it basically goes through and codifies the current system, where the department, rather than making the decision, makes a recommendation to the board, and the board then has 30 days to act on that recommendation. Section 25 amended the statutes that resulted from Act 48 by making clear that the board now has the authority to modify a recommendation as opposed to just approve or disapprove a recommendation. The department is then required to apply the board's decision within 5 days after the board reviews the recommendation. Vision and long-term care policies are exempt from the board's rate review, as are Medicare supplemental policies. I think that, did I miss anything in the favorite section?
And then there's just also some, a requirement that if on the off chance the commissioner does not make a recommendation to the board and time runs out, then the rate as filed comes over to the board anyway for the board to make a decision on either way, just to make sure that there is kind of no slowdowns in the process and that there's clear where jurisdiction was on 25.
Right. In that situation, it's treated as though the filing recommendation for approval. Section 26 clarifies that in the rate review realm, it is only the board's decisions that are subject to the board's appeal statute. In other words, the department's recommendation can't be appealed to the Vermont Supreme Court, which makes sense, but Section 26 just puts that there so it's clear. Oh, Section 26A, Consumer Protection Report. This is the one where I've often heard Georgia say it's sort of like everybody but us is involved in creating this report about us. The idea is to develop recommendations on how best to represent the public and account for the public's interest in matters before the Green Mountain Care Board. It's the department collaborating with the Ombudsman and the Agency of Human Services who are responsible for that report. This is something that we heard about during this legislative session. We had questions from various legislators about, where should we be thinking down the line as far as representing the public's interest in this process. And so this is a report that I think will be helpful and sort of enlightening on moving that discussion along. Is there anything else on that? I'm not super familiar with that provision.
The only other piece is that there has to be funding needs and funding mechanisms built into that, so it can't just be that an idea is presented, but it has to kind of show where the rubber meets the road in relation to this, so the legislature can determine what kind of investment they feel is appropriate based on the recommendation of these other agencies and the health ombudsman.
Thanks.
Could this also be construed or interpreted as a call for broader public engagement besides protecting consumer interests in terms of communicating with the public and what it would take to do that effectively?
I think based on the discussions that occurred in the legislature, this is really focused on specifically things like, is the healthcare ombudsman the right person or the right type of entity to be really representing in kind of a legal framework the public, or is it you know, the Public Service Board has the Public Service Department representing the public in a very specific role. So who's our Public Service Department? That
That
would
issue came up in the Senate Finance Committee, and I think George is right. I testified, and they asked questions having to do more with who, in a formal regulatory process, represents the public, and do we have that adequately covered?
And I got those questions in LCAR on the expedited rule as well. Okay, so, moving along, section 27 deals with payment reform pilot projects. Officially moves that responsibility from DEVA to the board in collaboration with DEVA. Moves the implementation dates forward, so now there needs to be one in place by July 1st, 2 or more by October 1st. And those dates move from January 1 and July 1, respectively. And makes clear that after pilots are implemented, insurers can appeal the board's decisions. And that's an area where I still need to do a little work developing some rules around what those administrative processes look like. Section 28 addresses the blueprint, requires the blueprint to collaborate with the board, in addition with FINREG, on health insurance issues, and places a representative from the board on the blueprint's executive committee, replacing the representative from FINREG. So once again, the sort of the board department transition going on there. Sections 36A and 36B amend the preconditions that must be met for Green Mountain Care implementation, and requires the Joint Fiscal Office to review the board's findings that the preconditions have been met within 90 days after the board makes its determination. Sections 37 to 39, a number of technical and clarifying changes. Probably sections 38 and 39 have to do with sort of board membership itself. Allows a member of the board to submit his or her name for consideration for reappointment. Specifies that names of candidates submitted but not selected remain confidential. And section 39 clarifies that members will continue to serve until their replacements are appointed, so that there's not a gap if for some reason a replacement hasn't been appointed at the end of a term. Sections 40 and 40A deal with rulemaking, a topic near and dear to my heart these days. Allowing the board to use the hospital budget rules until the earlier of March 1st, 2013, or adoption of our own hospital budget rules. As a practical matter, that allows the board to use the existing rule for the current process, because there wasn't time to get the board's own rule in place. H559 also requires the board to adopt rules by January 1, 2013 on insurance rate review and CON review. So we have the insurance rule in the pipeline, and the CON rule and hospital budget rules will be close behind. And finally, section 40B, George's other favorite, transfers a position from the department to the board as of January 1.
And that's associated with CON.
Yes.
Yep.
Just going back to the blueprint section 28A, the last point, all health insurance plans, including multi-state plans, participate. This came up in one of the meetings that I was at. Somebody specifically asked if a health plan that is not based in Vermont, in other words, it might be multi-state, but Vermont's not one of the states, but Vermonters are getting care there. Does Vermont have this blueprint, or do we have any relationship to that plan, other than collecting information and expenditure report because the Vermont citizen got their care there? So with such a plan, let's say it's in New Hampshire, but that particular insurance company doesn't do business in Vermont, it just is in New Hampshire and somewhere else. But it's a Vermont citizen, so they would be included in the expenditure report. but do we have any capacity to regulate, to know what's happening, to have input about that health plan?
They're licensed in another state.
I think we have some of it if they're Vermont residents. I don't actually know if they have the specific rules. I know there's some allowance for if there's very few Vermont residents, we say that we don't have to bother with those carriers and say that there's some of this reporting requirements. I can look into specifically to see where those thresholds are, and what exactly the information is that we collect on them.
Yeah, you had told me that before, and that's what I told the person asking the question, but I just wondered if it was clarified in this 559. Okay.
But if they don't have a license to sell insurance in Vermont and they're not actually selling insurance to Vermonters, they're selling insurance to an employer in New Hampshire and Vermonters happen to be covered by them. I don't think
That's
they
it.
have any jurisdiction over them whatsoever.
That concludes this portion of today's program. Do you have any other questions?
Well, that sounded good. All right, any other questions for George or Mike?
For next year's review of next year's legislation, I'll do like a dramatic reading, interpretive reading.
Dance. I'd like to see some dance. Well, thank you both for your hard work on this bill. I know it looks really simple when it's all done, but I know you've put in many hours, Georgia in particular.
And we're already working on next year.
Let's take a year off. Okay, so unless there's any other questions, I think we'll go on to new business. And we have a couple of items. We have,
There's an RFP that we'd like to issue, Stan. Did you send
let's
out
have two of them.
the RFP bid?
Should be up there in the back.
I have one. We have the Unified Healthcare Program.
Yeah, so there's a contract for the Unified Healthcare budget, and then there is an RFP we'd like to issue related to actuarial services. So we'll start with the contract since that's apparently people have. So this request is to execute a sole source contract with Dr. Stuart Altman, and relates to our development of our Unified Healthcare budget. And actually, we're on this statement earlier, the statutory language is here too.
There you
We
have
just
it.
love cutting and pasting
Yep.
our obligation related to the Unified
We've done it
Healthcare
once,
budget.
we might as well do it. Yeah.
But as Mike said, that this has been in the statute for quite a while, but hasn't really been utilized very well, and we're working to utilize it. However, it's really hard to do this. Implementation of the Unified Healthcare budget is exceptionally complex, and we need some specific technical assistance, and that will be provided by health economists and health payment experts. In doing some research, and I thank Anya for half of this work, there are very few people in the country who can do this type of work and think in this way. There are many health economists, but they all specialize in different areas. Dr. Altman has knowledge and capacity specifically in this area of building unified systems budgets. We've had some preliminary discussions with him, and he's willing and able to work with us. There are a couple of others. One is Jose Reinhardt. He doesn't have capacity to work with us at this time. And then there's some folks on the West Coast who are also pretty much full up. They're doing some work in Oregon. I included a brief bio of Dr. Altman, but he has proposed that he would work with a small team and us to identify and to help us identify the basis on which we can make a decision regarding healthcare trends and growth rates. And so this is to ask for approval to execute a contract with him and any subcontractor he's identified and that we agree to. The totality of the contracts would be limited to $20,000 exclusive of mileage reimbursement.
Is his career is primarily in academics? Is he full-time academician, or how does that?
I don't know if he's full-time anymore. He was full-time up until maybe 2 years ago. He may still be considered full-time. although he's not on Granda's campus as much as he used to be. I'd say his career has been a combination of academics, work in the federal government. He worked for HEW, and years ago actually was involved in the Nixon healthcare plan, believe it or not. And then he was the chair of PROPAC before it changed its current incarnation. Has been an advisor he was an advisor to the Clinton administration, and does a variety of consulting now, but I'd say he's primarily academic these days.
And I guess this is the hope that we kick off at the end of, maybe at the end of this month or early next month, to start our work into this. We can complement the work we're doing tomorrow with the advisory committee.
So he'd come to the board?
At some point, yes.
Yeah. The other thing I should mention is he's worked with a couple of other states. He's very involved in Massachusetts right now with their efforts to develop the two bills that are in their legislature, and has advised both healthcare providers in the Boston area and the Patrick administration on healthcare cost containment, and he also has worked a lot over the years in Maryland.
And I believe he's done some work in Pennsylvania.
Yes.
Move that we approve the execution of a sole source contract with Stuart Altman.
Second?
Any other questions? Concerns? All in favor?
Aye.
Okay, thanks.
So
And then we have one other.
we have one other, it's a bid for, it's to allow us to send out a simplified bid for actuarial services, and I apologize, I don't have a hard copy for you, I sent it out yesterday. All of you, in summary, what it would do is allow for a one-year contract of actuarial services so that we can rely on their services to do some trending and forecasting around payment reform pilots, to help us in developing policy around rate review, so not actually reviewing the rates, but help us with some of those larger issues that we want to work on, help us work in similar policy development around hospital budgets, and perhaps unified healthcare budget or certificate of need, areas where we need solid trending and forecasting. Not having had the bids in, I can't tell you exactly what they're going to cost, but actuaries by the hour tend to be fairly expensive, given their line of work and how few of them there are. My expectation is it would probably be around a $70,000 a year contract for the year, but it would be hourly based on a project basis, so we would be able to structure the contract over time in that area. But also, I want to be cautious about saying how much it would cost because we don't have the bids in. So the hope would be that we send it out to a handful of folks who do actuarial services, 4 states, and then we get the bids back and be able to execute a contract in mid to late July for the services for 1 year.
Are there firms in Vermont that could do that work?
There are a couple of them, and there's a couple of them, and some of them are conflicted because they work for either the legislature or they work for other branches of government. So it's we'll be looking at a combination of folks who are available who also aren't conflicted. So, for example, the Department of Financial Regulation has a contract actuary. I would feel comfortable asking for them to also serve as our actuary, given that they have that conflict. But there are some big firms, and then we look at some smaller firms so that we can get a sample of bids to review.
Would their expertise extend to the benefits arena as we try to think about developing best practices or similar guidelines for how we would think about the reviewing of the administration's recommendations around that?
I think that's possible. There would be an actual question of timing, though, given that we won't have this contract in place for at least a month, and I'm not sure how things work through. But I think one of the hopes we have is we've had several conversations where it seems like actuarial services would be helpful to advance some of our policy goals. So this would allow us to have someone who would help us with things like that. So I think the possibility is there, but I'm just not
The
sure.
main focus would be trending and
Forecast.
solidifying our assumptions about healthcare cost growth.
Yes.
Okay, any other questions for Georgia? Comments?
So, well, what are we doing? We're approving a bid approval process?
Yes,
Okay.
We're approving release of an RFP.
yes.
Okay.
Well, it's a simplified bid, which means that we target who we're sending it to versus just a broad reach. So we'll probably send it out to about 5 or 6 different entities across the country, and then they'll get bids back to us in, I think, 3 weeks.
Is there anything that precludes other entities from bidding?
No, because it'll be on the bid board and it'll be available on our website.
Move that we release a limited RFP for contracting actuarial services over the next year.
Second.
All in favor?
Aye.
All right, thanks. Any other new business from you all? Okay, public comment on these grouping subjects? None? Okay, I know you're all going to be really sad about this, but this is the last time you're going to this room. We thought about having cake to celebrate the occasion.
Yeah, it would be an orange cake.
All right, I think that's it for today. Thank you.